Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. This edition, we're looking at domestic violence cases and whether or not one judge can, follow another judge's notes. And in the case of CC versus MZ, the appeal court said the judge should not take judicial notice here on another judge's notes. So the defendant appealed the trial judge's granting of a final restraining order under the Prevention of Domestic Violence Act. The plaintiff had obtained a temporary restraining order against defendant. Trial court scheduled a final hearing, but the date was continued several times due to administrative issues. In the meanwhile, plaintiff amended her TRO to allege a history of domestic violence, because there was this amendment. There was an argument, the predicate act of contempt of domestic violence order. So upon a hearing before a different judge, plaintiff testified she received text messages and a written letter from defendant after the entry of the TRO. Defendant's letter referenced, quote, seeing plaintiff on a particular date, which became the subject of an inquiry and confusion amongst the trial court and the parties, namely as to whether the date referenced a scheduled hearing matter. The trial court then accessed the court's records to take judicial notice of scheduled hearings. What happens next? It's granted, but the trial judge did err in subsequently taking judicial notice of statements made by another judge without notice to counsel in advance or an opportunity for counsel to be heard on what the trial court had discovered before the entry of the FRO. The appeal court remanded for the limited purpose of allowing counsel to be heard regarding the propriety of trial courts taking such judicial notice. The appeal court also remanded in light of the trial court's findings under the second silver prong, as the trial court concluded defendant posed an immediate danger to plaintiff in reference to the closing arguments of plaintiff's counsel. The record contained plaintiff's testimony supporting the counsel's closing remarks, but the attorney's summation was not in evidence. And this is the case of the CC versus MC, and that's an unreported appellate case. For more information on domestic violence cases, visit website njlaws.com, and for representation, contact Ken Vercammen's office in Edison at 732-572-0500. Thank you.